straightforward solution. Lord, we thank you that we have got men and women that are willing to volunteer, to put themselves in harm's way to protect us, both abroad and here locally with our first responders. Lord, we thank you that we stand under a Constitution that protects us all as citizens and allows us to operate this way. And please, please help us never to take that for granted. Lord, we'd ask that you'd go with us. We have members of our county family that are hurting, that have medical issues, and we'd ask that you'd wrap your arms around them, help them through tough times like you always do. Lord, thank you for the many blessings you bestow upon us, including the rain that's failed and healed our parched land. These things we ask in the name of your precious Son, Jesus Christ. Amen.
Amen.
Thank you, Christian. Y'all join me in the Pledge of Allegiance, please. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Now the Texas pledge.
Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you. Take seats, please.
Margaret Rogers.
I guess we can start that.
Yes, we'll wait to see if she and the judge.
Man, I was all geared up.
Me too. I was thinking about that this morning. Looked
May
at
just have to go anytime.
If I could ask the court to take action on the consent agenda.
So moved.
I'll second that, Judge.
Thank you. Motion by Commissioner Harvey, second by Commissioner Waller, approve the consent agenda as presented. Any questions?
I had a question,
Yes,
Judge. On item number 4, was that the entirety of our jail transfer during jail school?
Yes, sir. There were 3 bills they sent on that. I reviewed those, took them down. Sheriff, he then asked his personnel to look at that, and that covered the people that were there, and it covers the transport for taking them back and forth for medical. We had some of that, and that was priced in accordance with agreement. We did catch one error in that and reduce that, and there was also an actual medical expense in there.
Well, that's considerably less than what we had anticipated.
Well, that was 3 weeks instead of, and you all had a number of them that came up during that time that bonded out and things like
Came
that.
back here for trials, we didn't have the full amount there full time that we anticipated.
But you think it helped, it looked like from time and everything else, we met the other goal, which was to provide a little bit of relief to jail personnel. Okay.
And then item number 5, Judge, just clarification, I didn't know quite what that entailed or who was leading that charge.
Commissioner Harvey,
This is on the
Chip Spreader.
the
New one or old one?
the new one.
New.
That bill needs to go to Box, is who that needs to go to, or
Well, problem is, we've had so many people work on it between the time we purchased it until now, that I don't know that you could get boxer equipment to stand by that.
Well, if it had gone back to them, you might, but I don't think they haven't done somewhere else. They're
We,
gonna do.
we replaced some hoses. Apparently the hoses got hooked up backwards. Hydraulic motors didn't work properly. The belts were, I'm gonna say, not calibrated properly or not tensioned properly. And when you put rock in the box, they would just stop. So we have got all that stuff fixed, and we have played with or practiced with that chip spreader in our yard several times now, and it apparently is working properly at this time.
I would bet
This-
that was a lemon brand.
This bill here is for a place out of the Metroplex.
Okay. Any other items on that? All in favor, signify by saying aye.
Aye.
Opposed, same sign, motion carried 5-0. Okay, first item is review and approve the regular bills for payment.
Judge, we reviewed the bills on Friday. I would make the motion that we approve them for payment.
Is there a second?
Second.
What about those bills we pulled out?
We ain't full, and we just discussed. The card bills?
Yeah, that's what, I was trying to think, while I was trying to
It's an
think.
agenda item for
But we-
next Monday.
Next month.
But we called on that and clarified that, what it was,
It will
yes.
be an agenda item for next Monday.
Okay.
Okay. Any other comments on the bills or questions? Okay, all in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries 5-0. Item number 2 is discussions with Central Magistrate's Office on jail population. Judge Newman, you're going to lead that off, or you're going to introduce?
I'm going to.
Turn it over to-
Introduce Terry Biden.
Very good. Thank you. Ms. Bottenheimer.
The jail population was increasing. I don't know if it had something to do with part of the, we didn't have a grand jury for almost a month. August 15th was the last one in August, and then the first one we had in September, everybody was out of town, so it was September 12th. But we're still doing the same thing we were before. In August, we dealt with 100 people. July was 93, and then September so far this month, 79 that have been released. Which is what the judges are doing. Still the same amount. We do have 161 people in on no bonds for just this year alone.
No bond.
No bond, whatever, they're either parole violation, benchmarks, something they can't get out regardless of what. There's 185 in when I did the count the other day, but as of, for 2018, it's 161 for this year alone.
For the year, not current in the jail.
Yeah, there's 185 currently. Still 2 from 2015, 4 from 2016, 18 from 2017, 61 this year.
If someone's been in the jail for 3 years, wouldn't you think that we could have got their case through the courts? I mean,
It's not-
we're just asking questions.
That's up to your prosecutors and stuff, the DA's office. Some of these people are in on murder charges.
Murder?
Some of them are in on murder. and-
Yeah, that makes sense. I mean, murder trials are,
That particular one agreed to a plea bargain, and it once again reneged on that. I'm not sure what the judge is going to do to handle that, but, yeah, that's the 3-year one.
so how many people have been in there multiple years?
Let's see, I've got 2 from 2015, 4 from 2016, and 18 from 2017.
Meredith, do you know how that works?
Hey, well, I mean, it's really not up to the DA's office. Yes, we charge them. But if the public defender's office or their attorney on the case asks for a continuance, they're gonna get a continuance. So, I mean, if they ask for a speedy trial, they'll get a speedy trial. But the court docket in Judge Bernard's court is severely backed up. So it's really not, I mean, the DA's office is aware of people at docket that have been in there for multiple years and keeps track of that.
So they do know, and they haven't fallen through the cracks.
You have people that maybe have gone off for a competency evaluation, spent 9 months or, less in getting competency restored. So you're always gonna have some that cross over some years.
Okay.
Complicated cases take a long time to prepare. They may have.
I figured the
hired
murder
an
trial.
attorney right before trial and had to get a new attorney, or public defender's office conflicted off and had to get a new attorney. I mean, I will promise you, it's less likely that the DA's office is asking for a continuance. We
Oh, yeah.
very rarely for those, as opposed to the other side.
Well, I didn't know how it actually worked. I didn't know if they could say, hey, I want to move these to the front of the list, or
Yes, they can.
they
And
can't.
they do. I mean, that's why I said they try to make sure that they're getting the oldest ones, if it's possible, because some of those cases just aren't ready to go to trial. So.
Okay. Thank you. Okay, item number 3 is discuss and consider take action to amend court order. Ma'am?
I think there was some more discussion on that item.
Oh,
Did
I'm
you
sorry.
want us to do it now, or?
Yeah, go ahead. Yeah.
I did want to make the court aware that there's been some with the advent of all of the PR bonds that are being issued from CMO's office, I pulled our bond forfeiture revenue for the year and our bond forfeiture cases. I looked at how many had been filed this time last year. Our bond forfeiture cases at this time last year were 244, and we have only 186 this year, so we're getting less bond forfeiture cases because they're PR bonds, and we cannot chase PR bonds. We're never gonna collect those,
No.
and it's not worth the time to try to collect those. The revenue has seen almost a $50,000 decrease. So, where we used to maybe reduce a bond to try to get somebody out, they might still be on a surety bond. Now those people are getting PR bonds, and we're losing that bond forfeiture revenue as well. And I think, I don't know. I'm not, if y'all like that.
Judge Newman.
We've got a breakdown of bond forfeitures so far for this year. We've had 118 on which there were bonding companies or attorneys. 48 were on a list suggested for PR bond by the county courts at law. 9 people, 9 bonds were forfeited where we had reduced the bonds prior to the 15, 30, or 90-day release. And of those that state the maximum length of time that the law permits without getting information or indicted, we had 7. One of the difficulties we have on some of these that stay the full term is you spend 90 days in jail, you don't have an address for mailing. But if you'll read the statute 17.151 of the Texas Code of Criminal Procedure, it doesn't say anything about you gotta have an address to get a PR bond. It says you got a PR bond release or a bond that they're able to make. But if they haven't made, we go through a reduction process with these people. If they're in for a $25,000, they haven't made it in 30 days, well, we'll consider $10,000. Can you get a $10,000 bond? Can we get some kind of surety? We'll sometimes reduce them 2 or 3 times before we finally grant them a personal bond. Now, if they don't have an address when they fill that out, we can't help that. They just don't have an address. We could send the mail to general delivery, we could set up some kind of pre-trial office at some expense to the county to keep track of those people, to have a weekly check-in, something of that nature, so we know sooner that they weren't going to appear for hearings. But we don't have any other option when they reach their maximum in custody time.
Okay. Now, there are exceptions to that. Is that correct?
If they've been found to be incompetent, that time doesn't count against their maximum retention. If they hit maximum retention and we release them and they violate a bond condition imposed at the time of their release, we take them back into custody, and then there's no time left. They can just stay.
But there also are things that they've been accused of that you all do not consider that PR bond, is that correct?
Correct. Yeah, there's a laundry list of things that at the very least we must notify the district attorney's office, give the state an opportunity to have input on those cases. Without notifying the DA's office, we wouldn't touch one of those cases for the 10-foot pole.
Right. Okay.
Judge.
Anything else? Yes, sir.
We understand the bond, I mean, we have to give PR bonds according to law, but we also keep a set of stats for when they're coming back and when we have warrants on them. Of the 1,902 bonds for this year that have been issued. Since 2017, so a year and 9 months. There's been a total of 1,562 inmates that we give PR bonds. 638 of those have come back, and those that came back, 380 came back with new charges. So we are, actually more than that, 179 had bond forfeiture and a new charge. So nearly 580 have come back with new charges or bond forfeiture and new charge. We're showing a recidivism rate of 40.85. So 4 out of every 10 we're letting out coming back. with new charges or just coming back to not taking care of business.
Okay, 4 out of 10 or 4.85%, there's a bit.
40.85%.
Oh, 40. Okay, I didn't hear.
40.85 are coming back.
Did you happen to look to see whether that was, how many of those before we started doing this?
We just started.
I'm just saying, I think a lot of them were pretty much frequent flyers, even if they had.
They probably were. We actually, patrol the last couple of weeks, been trying to hunt some of these down. And we went through 63 addresses, looking for 63 individual different people. And some people we looked at multiple addresses, can't find them, no longer at those addresses, or at a previous address or a work address. We did arrest a few, found a few deceased that had been off. We'll take care of them. So we are seeing, I understand we have to let them out on PR bonds. A lot are coming right back. And I think what bothers me the most is they're coming back with new charges. So they're just creating more work for court, more work for the DA's office.
Do you have any kind of a breakdown, how many of those were bonds that came out of the magistrate office and how many were posted?
These were all out of the magistrate's office. These were all PR bonds out of the magistrate's office. That's all.
No, Will, anything that you or Meredith see that would be, I mean, is 40, is that high? Is that norm?
When we
Is that?
first started tracking it, it was like at low 20s, and then as more and more bonds, it just continually went up. So it just, I guess the more we let out, the more that rate's going to grow, because they're going to go out and commit other crimes, and they're going to come right back. Which, again, creates more of a backlog in the DA's office, and then for everybody, it creates more work.
Well, the good thing about that is if we're writing PR bonds and we're lowering our jail numbers, that's a good thing. We want to do that because it costs us less. But if they're going back out in the community and committing crimes and coming back in,
We're not protecting the community.
we're not protecting the community. So you've got two different standards there that you're dealing with.
But you've got a significant number, I'm going to say, in that group, that even if they stayed here, went through the other process, took a plea agreement, went back out, they're going to be back in 60 days.
Yeah.
And they are.
Yeah. I don't know as we can say it's all one way or the other. It's
When
a
you-
mixture.
I'm sorry, Judge.
That's right.
I had a question. When you write a PR bond, personal recognizance means exactly what it says. You sign a piece of paper and say, I'm personally responsible for coming back and appearing and doing what I'm supposed to do. And if that doesn't happen, you have no recourse, really nothing to go. And we're writing those ourselves. We don't have a bond person or somebody else doing it. So there's no recourse whatsoever.
Judge Butler?
Yeah.
Okay, there's like lots of issues flying around, so I'm gonna try to stay organized. Well, I agree, and I understand 17151. However, my docket this morning, just an example, out of 21 PR bonds that had the opportunity to appear, 9 did. So what you have happen is a warrant gets issued because it's a bond forfeiture. They can't collect on a PR bond. I mean, it's a practical matter. So the warrant gets issued. Then there's manpower eaten up from the sheriff's department, PD, any of the agencies, to go ahead and try to get this person back into custody. There's not really an active team that I know of that goes out and does it. When they get picked up, they get picked up. So they're picked up for a new offense a lot of the times. But then there's also another fee that goes on top of that if the warrant gets issued, okay? Well, then they come back into jail. So I understand Mr. Mahler's, we're saving money by getting people out, but are we? And I don't know if there's a way to track that cost. The other issue is appearing for court to dispose of the cases. As this court is well aware, the number of caseload at the misdemeanor level, where I think the PR bond is used probably more so than the felony level. The problem we run into is the added cost to the courts to try to get these people back in. The only recourse I have is issue a warrant. And they do give Anywhere USA address, something along those lines. I saw it twice on the docket this morning. So how am I getting notice to these people for them to appear? We're not. The only solution, in my opinion, well, two things are coming. Bail reform is coming, so get ready. This new jail you're going to build, I don't know how you're going to put them in there, but you might start looking for some innovative ideas to contract. Because if this bail reform hits like it has in other states, it's going to significantly reduce the population without our PR bonds. The other thing is too, it is going to be the use of more PR bonds because that's typically the only way you can get bail reform through. Bail bonds can have a strong lobby in Austin, and they're fighting against it, and they've already started. But the governor's already put out an initiative on it. There's already been 2 or 3 other legislatures that have looked into it. And so it's coming, so be ready.
What will it do, Judge?
It's going to significantly reduce your population of this jail that you're building for whatever, how many people it is. You're going to be operating at about a third of that.
And that's because
Bail reform.
bail bond reform?
California just put bail reform in and essentially turned everybody loose. So they're screaming. Now, there's a lot of private facilities out there that are screaming already. So there's 2 things working. You got bail reform coming. And then I think as part of some of the bail reform, they're going to be requiring counties to run a pretrial services office. And they already do that to some extent. But if you're going to be doing these PR bonds, and we're going to be hit with this bail reform, then for God's sake, for once, can we get out ahead of it? That's what we're doing.
Except for the pretrial office.
That's what I mean. Can we get out ahead of it?
We've got it in next year's budget.
Well, it needs to be set up right, it needs to be funded right to try to move some of these cases through. Because what you're going to get hit with, if bail reform comes and you got a big jail, you're going to have a big jail sitting empty. You're not going to have a pretrial office that is operating properly. And we're going to have a mess on trying to get these people in through court. My concern is to get them into court to dispose of the cases. 99% of the misdemeanor cases, 99.9 or 80%, they're pled out. But we got to get them into court to get them complete out. So that's my concern. We got to have some sort of check over this to get these people to the courtroom.
Well, what's the problem, I wonder, on getting misdemeanor cases filed in time to get that done? You know, that's part of the problem. They're being let out by a matter of law, and we're not getting the front end loaded to keep them
I
there.
don't know how many misdemeanor cases, Class B misdemeanor, you sit for 15 days or you're let out. Class A, it's 30 days or you're automatically let out. I try to do a jail run every week, so I stay on top of it as best I can. But I'm the one who has to run that. I don't get notified from anybody. Sometimes CMO will notify me that we got one sitting, and okay, I'm going to run. 9 times out of 10, they're going to have felony pending with it, and they're not going to plead the felony out, or they're not going to plead the misdemeanors out until the felonies dissolve, or resolve, excuse me. So those are the issues we're running into. If you're talking about the delay in getting the cases filed, agencies have to get their packets together and get them to the DA's office. Some agencies are better than others about getting it to them in time. And then the prosecutor has to review it, and then it has to be filed, and it has to go through that process. So it's not boom, 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 it's done just like this. Perhaps with some sort of electronic filing between the agencies and the DA's office that's been talked about before, that might speed the process. I don't know, because I'm not on that end of it. But getting the case filed, yes, that could be an issue in some instances. It just depends on the agency. A lot of times with the TWI case, you're waiting on blood results as well before they're confident to go ahead and file. And that's a new feature of the last 4 years, basically.
Judge, are you talking about the DPS place that we send all our
Lab.
lab?
Lab, yeah.
Is that the DPS
Yeah.
one?
Yeah, I think that's who they're still running the blood through. It's a DPS lab.
Are we allowed to use other labs?
You have to, well, even if you use another lab, it has to be certified by DPS, so.
Here's one.
That's what we ran into when we were having all the problems with the drug results.
Yeah.
Is that we thought about using another lab, but the problem is you can't just go set up a lab, and those people aren't used to testifying, aren't qualified, they have to be certified by DPS, so.
Yeah, I mean, my whole deal is, I gotta get them into court to dispose of the case. And when you're getting 2,400 plus filed misdemeanors a year between the 2 courts, it's very important that we're able to move the cases. If not, we get stacked up, and we are stacked up. I mean, I'm running dockets of anywhere, I don't know, this morning was 60-something on an arraignment docket. Tomorrow I'm probably gonna have 80 to 100, and I'm running that every Monday and Tuesday. I mean, we're getting to a point to where something's gonna have to happen, because we're stacking up.
Do we need a third county court of law?
I don't know, we've talked about that before. mean, that's the cheapest thing for the county. County Court of Law is operated at roughly $300,000. I don't know. One, we don't have room, so I don't know where you're gonna put them. But, I don't know. And the legislature will typically give you another county court of law because they don't have a whole lot invested in it. District courts are the ones that are harder to get. I don't know. I don't know if that'd be the option or not. It may be something we look at, but, you know, there's other things to consider. We've got a lot of stuff that's coming down the pipe. And you need to get out in front of that pretrial services office, however you want to set it up, wherever you want to put it under. And I know we've been looking at some different models. I think that's going to be essential to this, because I think with the bail reform coming, from what I've seen, you're going to have that office.
Judge Hogan has actually said something about being willing to help us with something like that.
Pretrial services office or a third county court of law?
I think the third.
Yeah, I know, he had said something about that to me in the past, but there's lots of different factors that go into getting the cases moved. I mean, there's difference. But one, if you don't have them there, you don't have the opportunity to move them. So getting them there is a priority. So just wanted to do it for you from my standpoint. I can't speak for CMO or Sheriff's Department.
So you think the solution?
Yeah, I mean, you know, one of the biggest hurdles for us in doing a pretrial services office has always been, I mean, the counties that we talk to in the Tyler project that are doing real pretrial services, where they're never put into the jail at all, have 24-hour registration. And I don't think we'd have to have 24-hour, but we certainly would have to have 7 days a week, 8 to 5, you know, to be able to get people magistrated, because they can't waive that. You've got to get them magistrated before they can have their charges filed and the case disposed of. So, you know, we haven't figured out really in our current system how to do that. That's going to have to be a change if we really want to have a pretrial services program.
Okay.
On the waiver issue, that was one of the more interesting decisions out of the AG's office. Yes, the defendant can waive appearing before a magistrate to have the rights written, but the magistrate can't waive. So it's one of those kind of meaningless decisions. On the subject of bail reform, do get yourselves ready for this. I had the opportunity to read multiple times Judge Hecht's committee's recommendations for bail reform in Texas, some of which have already started to be implemented. And then this last fall, I had an opportunity to sit down with Judge Hecht and discuss what the heck. Harris County is responsible for a good deal of this. But basic premise is going to be that anyone not charged with a violent offense is automatically qualified for a person bond.
Well, if I understand this right, if we're going to let a whole bunch of them out on a PR bond anyway, it would certainly make sense to have the pretrial services, because you're doing the same thing and you're never booking them into your facility, which is going to save you time and money and effort, and it just streamlines the process that's going to happen anyway.
Well, they're still going to go through the booking process. Though.
Yeah. But you're going to rearrest them again for the same. It's a behavior issue and a lifestyle issue.
I don't know how they get out of it, because some counties actually have an assistant DA in there, and they're pled and done when they walk out. I don't know how they do that.
Well, that's what we looked at. They've got a magistrate who magistrates them, the DA charges the case, and they dispose of it.
But when they've had a PR bond and then they come back that second time, which we understand we're getting back, what, close to half of them, or maybe a little more than that, then you don't do the PR bond the second time.
No, you
You do. See, that's where I thought, you do it again.
No, it's a
wonderful.
revolving door.
Wonderful.
Except for criminal trespass, though, it's not done the same day.
Yeah.
We give them a little time.
But now if somebody's committed a violent crime, then all bets are off.
Yeah.
Well, you brought up the deal. I wrote
So
a
we're
grant.
stacking paper, Will, is what we're doing.
I wrote a grant application and asked Indigent Defense to fund 2 assistant district attorneys and additional public defenders to do just what, and it didn't make it, but they said, well, why would we fund prosecutors? I said, is the goal to get people through and get them to a court or not? I said, that's half the process.
Yeah.
And they actually did give that some thought when we discussed that down in Abilene at that conference. And
Ultimately, the goal of the state's direction that they're trying to head is to have an actual, more or less, a website or a software program where you plug the defendant in and it gives you a green light, yellow light, red light.
yeah,
There's probably nothing wrong with that system, but I'm so old school that it's a concept that I'm having a little difficulty dealing with.
well,
But we are actually I consider Wichita County fairly progressive in an awful lot of things that we do, and we have taken steps in making sure that when this comes, it's not an if, when, it won't be quite such a culture shock, because we're already doing a good deal of it.
Well, how do you staff a pretrial office? I mean, what do you got to be able to magistrate. So you've got a certain person that has to do that. And what else how do you staff it?
It depends on which model you use and the way you set it up.
Okay.
I mean, because there's different models out there. I don't know if we're to the point to where we would be running 24/7. I don't know if we're that big, in all honesty.
I could see Harris County doing it or something like
They
that.
do
but-
it. Collin County does it with a staff member who works at 5. She's the main person that handles the pretrial diversion, or pretrial services. And we've been talking to her to get more information about how that works and what all staff is required. But they do have the availability to magistrate somebody if, at any time.
Well, do you staff it with prosecutors and defense attorneys, or?
They do not staff that.
Yeah.
I think they have them available from 8 to 5, which we would have, to make decisions on charges and et cetera.
And I assume a bunch of it would be indigent. I mean, is that a fair assumption? So
oh, yeah.
does your indigent defense team gets involved, I would assume?
And on misdemeanor charges, they can waive their right to an attorney
Yeah.
and plead out their charges without an attorney.
Okay.
One of the more simplistic starts to that would be on these personal bonds or surety bonds, actually. Although with the surety, we usually do their own pretrial. If we have a staff member that can require, so that people know when they're released, what their first check-in date is. You're being released today, you will check into this office physically next Friday between 9 a.m. and 5 p.m. And the first time they miss, well, then we're out looking for them again.
And I would assume sooner the better. I would just assume
Yeah,
that.
yeah, it's like anything else, the sooner you
But-
act.
That's what one of the models of pretrial service office, very simplistic, basic pretrial services office. The people that receive PR bonds, one of their bond conditions is to report weekly X time to X time in person to this person. So you've got it set down as a condition. When they don't report, then the bond can be revoked, or they can have another opportunity to report, whatever that may be. And when they report, all they do is simply review the status of their case. Are you going to be representing yourself, or are you going to apply for court-appointed counsel? Go ahead, before the case is filed, let's apply for court-appointed counsel and get somebody in, which is already done in magistration. Sometimes they fill it out, sometimes they don't. So that way you can make sure the application is complete, whether it's been accepted or denied, who your attorney may be. That way they have the contact information for the attorney. 2, look and see if the case has either been indicted or an information filed. So what's the status? Okay, you've got your first arraignment at this certain time. So you review that with them every time they come in, and that way they know you're on top of the case and know that you have a higher likelihood, hopefully, of getting them to court because they know of their time. Bondsmen have the incentive to go to court. So the PR bond, when we know that the person is indigent and the PR bond is $1,500 or $2,000 or $1,000, it doesn't matter. The person's indigent, we know that if they miss that bond, the only real recourse we have is a warrant, and then everything starts all over again. So that's the way that I look at the pretrial services office, because it's typically just from my point of view. But then there's other ways to do it too, which is never having to really actually come into the jail. But if you know you're going to be released, those lines, it's typically going to get a PR bond. Then you're moved through a different section on the way the magistration works and the release.
Well, there's been a reluctance in many of the counties to use the ticketing process for those eligible charges for A's and B's.
Yeah, that comes through the other agencies as well. I mean, it's not just the district attorney's office. I mean, that's an agency decision. Does the police department want to do that? Does the sheriff's department want to do a ticketing for possession under 2 ounces or whatever? And then you've got a whole other issue, which isn't a big one. You just have to set it up with the courts that they would be in. They have to appear at a certain time, like a traffic ticket. And then it has to go through the DA's office because information still has to be filed, et cetera. It's a little bit of a process.
It is, but I'm wondering, Judge, if it wouldn't be, okay, if you do that, then you're bringing them in for arraignment and magistration at the same time, right? If they're coming back to the county court or not?
Now, magistration has to occur before, because arraignment only occurs after an information or indictment is filed.
Okay, but no, back to misdemeanors.
You're still going to have to, it's not technically a ticket.
If they write a
It's
ticket,
still a class
it's
B or
just
class
not
A.
Just-
You have to administer it.
Okay, I'm sorry, I couldn't hear y'all.
It's still considered a class B or class A offense, so you're still going to have to go through the steps. It's not like a class C. It has different rules that you have to follow. So I mean, you're still going to have to go through that process.
I'm thinking maybe when the legislature works on this process, that might be one of the things, if you give a person a ticket, you tell them to show back up in 14 days, and they can come in there that time, plead everything out, and move on. You've disposed of it in one move. Judge Newman?
Unless we changed our normal course of processing, this would still be people who show up next Thursday at 10 a.m., where ideally the citation and paperwork would arrive to the court, would determine probable cause, would read up their rights. It'd still wind up booked into jail. And then booked in the county.
But I'm just saying, if we're changing the process, let's change the process, but see what we're getting to. But we can't do that. That's going to happen legislatively. But the other thing that seems to be lacking is, especially in the misdemeanor area, that needs to get processed. Those are not as complex a case by far. We should be able to get those. You guys are sure making your courts available. So I'm saying if that was done, then we would have them adjudicated instead of them getting out because they sat there because the process didn't catch up in time.
I don't know if you can streamline the process enough where you're talking about like a walk in, walk out.
Well, that might be a little bit, if we could get it done in 15 and 30 days, we'd be improving the situation.
You'll probably need some legislative tweaking too, because they've already passed a law that says that you can take a plea in jail, in custody, but it's, you can renege on that within 10 days on Class C misdemeanor. And I expect that if anybody tests that, it would apply to any other case if you're under pretrial disposal in custody. People are under a gun. I'm either going to have to go back to jail and sit there while I raise bond to wait for trial later, or they're giving me the opportunity to plead guilty to something right now. They're in custody.
Well,
Which one gets you out quicker? That's the decision they make. It's really.
what we need to do is
I'm
probably
afraid, but you really
bring,
don't want to do that.
I'm sorry, is bring our efforts together that we're talking about here and here and maybe pick a path. The law is not going to change before June 1st or September 1st. So we've got a little bit of planning room and maybe even the ability to get some grant money in there. But we did set up $500,000 to look at funding the personnel to perform, and we've got to decide which task, but at least that's in there.
Our office downstairs can run the simplified version as long as we have an agreement between courts, because some of what we would be keeping track of would be cases that have gone out of our court, so kind of a dual jurisdiction. So by adding a staff member, we can put the people that we're putting on PR bonds on weekly check-in and update and do that. I don't have staff enough for it right now.
No. And you've got to decide, then, when they don't show, have you got the staff that's going to round them up? I think you've got to set some parameters and decide how much effort you're gonna put in this area and this area. But I think what we've discovered today is there's a lot to be developed and studied between here and June 1st or September 1st, depending on what the legislature does. Those are the 2 dates normally to do things.
And Judge, it would be wonderful to develop some ideas and concepts, and you can have some influence on that legislation if you go in with ideas.
Yeah.
They're wanting to write something that's going to work. And I know it doesn't always seem that way, but I think that's ultimately their goal. One other quick thought, I know
Yes,
you need
sir.
to move along. This pretrial services, I was thinking about a different aspect of this too, and something that just dawned on me. I would bet that there are some people that come through the system that are overwhelmed by this whole process. And having that pretrial services might add a component that simplified that a little bit to where you can actually tell somebody, here's where you need to go, this is when you need to be there, and this is what we're going to do. And sometimes it can be very overwhelming with all the different components of the system, and we might improve our numbers a good bit just by bringing it down to a more simplified level. There might be some benefits there. Because I just think it's a lot, and I know I'm kind of that way about making a doctor's appointment. Now, when was that? I can't remember, and am I supposed to be there Thursday? Just simplifying things sometimes makes things so much better. Do this, then do this, then do this. A lot of people respond a lot better to that than all the things that we discuss and look at.
Now you got to remember your login and your password.
Absolutely, and I mean, it just simple is always better. It's always better.
Yeah.
And there might be some benefit there that would help streamline some of this. So, I don't know, just a thought.
All right. Thank you all very much. Okay, item number 3 is discuss, consider, take action to amend Court Order 1611-710 dated November 14, 2016 to include maintenance for courthouse annex from Total Lawn Care and an additional quoted cost of $469.50 for 4 applications per year. Commissioner Watts.
Yes, I asked to put this on here. I did not realize until after the fact, and Tommy had requested some attention for the parking lot grounds over there, that we did not have that on our ritual of spraying. And when I went and walked it, it is definitely getting away from us with the weeds, and the grass burrs are just unreal, the number that have exploded over there. Careless weeds, and the grass is not too much out of bind, but the weeds are just getting ahead of us, and I think this would cure that, and that would address 6th Street, Scott Street, and 7th Street, and all the
Does that include juvenile areas and the other parking lot?
The other parking lot is already being done. And I just didn't realize that when we did this other parking lot, and that's certainly helped keep the grass level, and they do a good job mowing over there, and it's not, you don't have a foot tall weed and a 3-inch tall grass blade. They're all leveled up because we've taken the weeds out of them.
Careless weeds are doing very well right now.
Yeah, they are, but I was really shocked by the number of stickers
Yeah.
that are over there, and I know people coming across that end of 7th crossing Scott, and if you venture out into that grass at all, you're going to get them all over you. But with that, Judge, I'd make the motion that we add this to our current spray detail, and
I'll second that, Judge.
Thank you.
Well, can't we get Mr. Smythe to borrow some of your goats? Stake them out over there for just a little bit. It'd be a win-win. When you'd we'd eat the feed for your goat.
Absolutely.
Yeah.
I withdraw my second.
Okay, but you got to watch him. He'll try cooking some of them.
Which it would be okay too. They're good.
Okay, we have a motion with a second. Any questions, comments from the audience? Any more goats in the audience? No, okay.
I would make one comment, Judge,
Yes,
before we
sir.
vote, and it's related to this. I came up here Saturday to do some work, and it had been raining and all, and I tell you what, with the trees trimmed and the old diseased trees removed and the lawn care that I know the work crews have been working on, hey, our facilities look good. And it really makes a difference. You need to look professional. I just wanted to say, I was really impressed when you drive up and you see it, and it looks good. So there's some benefit. Anyway, just a comment.
Well, good.
Might look better.
Okay, all in favor, signify by saying aye.
Aye.
Opposed, same sign, motion carries 5-0. Item 4 is discuss, consider, take action to amend Court Order 18.08.662 dated August 27, 2018 to clarify the county subsidy amounts listed for budget years 2019 through 2022 are the maximum amounts for county subsidy of all of the grandfathered employees now maintaining dependent coverage continue to do so. The county subsidy amount will be less than the maximum amount as grandfathered employees retire or otherwise drop dependent coverage. The county subsidy for grandfathered employees will be as shown for each year following 2018 to zero subsidy in 2023. Those annual amounts are for 2019 is $67,831.26. For 2020 is $39,298.82. For 2021 is $18,553.06. And for 2022 is $5,791.54. Mr. Wall had prepared a sheet, but there was a difference in some of the numbers covered. We've received an update from the auditor's office on those subsidies. Have you all had a chance to look at that?
No, I just,
It's just how those were weighted and divided out. But the people with the larger will still get a greater share, and it staggers down to an employee with one child and the amounts they will get.
so we're working back from that total number?
Yes, sir.
Basically, okay.
Yes, sir.
So if you just get a 10,000-foot bird's eye view from it, basically it is, if the county is paying a portion of your premium for your dependents, every year it's going to drop by 25%.
Yeah.
It's as simple as you can get it. Every year you're going to pay 25% more.
Plus the increase in that premium, depending on which plan we stay on.
Correct.
We received some updated plans from Brian Nazer with Texas Association of Counties. Those came in last Thursday or Friday afternoon, and I visited with the auditor staff over the weekend, and we talked about that maybe, even though we said the other day we want to stick with exactly where we are, there's probably some significant savings to look at there, but there is not long to make that change because we're headed into the enrollment period. They have got to furnish that information to Higginbotham and prepare that for us. So if that can't be done, and they're also, this is the final week, this week on the capper, I believe.
Yes, sir.
So that's got pretty much their whole force, and then we're going to have a small thing in there for payroll. Not this week, but next week.
Yes, sir.
So, boat's loaded. So we'll see what we can maybe put together and see if there's something to do that we might continue.
Can we get Brian up here?
I think we can if we can decide on a date we can do that. Part of that problem is we're out that week right before that for the state conference, and some of us have hours we have got to get, so we're going to be there.
Is there, but what about the first week of October, Judge? Is that possible?
That's
Maybe
possible.
get Lou Ann in here
And I
as
just
well?
want to know if, they will both, but if you all want to take a look at that, but I think that's as late, and
But we could, if there was incentive on the insurance to change without making drastic changes to our HRA or developing an HSA in the ninth hour, we wouldn't necessarily have to do that piece, would we?
well, we need to know that actuarially, we have the appropriate amount of money if we're going to change the HRA plan.
Right.
And the health savings account, I think you had found out, or I've been told, the way the TAC administers that, it's paid out first.
Right.
And so you're obligated to that, and that's cash out the door.
Right.
Whereas the HRA, we limit, and it's reimbursement. So that's a little easier.
But we necessarily wouldn't, I guess my point is that we wouldn't necessarily have to develop an HSA at this stage of the game. We would just have to make sure we could fund the HRA if we're going to move those deductible amounts around.
Yes, sir. That's, yeah. And this year, you know, they're working and trying to get people that haven't filed. I mean, we're trying to make that as easy and possible as we can, but, you know, they can't go round them up and get them in there. They are notifying people and asking them to come in, bring their paperwork and do it.
Now,
We're gonna know a lot more about that in the next 90 days, Judge, what those totals really are.
Yeah.
We'll get that full year, and then we'll have some real numbers to work
But
on.
we'll have to, you know, we're gonna have to tie this down, what they're paying on the open enrollment. This document here will give us that, but those numbers could change again. But what we're saying, I think, in this court order, if all of a sudden the number getting family goes in half, we're not gonna redistribute that money. The money's gonna be based on the whole group, and that's
at
all.
these
At these rates here.
rates here.
And, you know, because that's a moving target, and maybe somewhere along the line, there'll be some other new plans come out but I sure don't see anything happening from the Congress that's gonna make the Affordable Health Care Act affordable. It's just not a good deal.
We addressed everything but the cost.
Yeah.
Pretty much.
That's kind of it. Okay. Any questions from the audience on this item? Yes, ma'am.
So even if some people drop out, that's not gonna help everybody in the grandfather.
No, ma'am. One, we've got to set it up, and I don't know when people are going to make that decision to do that. And this year, they may tough that out, that difference. It's going to be the next year and the next year, I think, are going to be the big eliminators. This year may not be. But someplace, we had to draw the line and establish the money. And we had to use.
So would there be a possibility since it's so this year, 67,000, you only spend 60,000, that $7,000 can roll over to the next year?
No.
No.
That's sufficient court.
But I think this addressed the intention of the court, Judge, because this started out as a budget decision, and we're setting it up that way. I mean, I think it reflects what we intended.
Okay.
As a plan, I understand this, but the 39,298 set aside for 2020, would we not be better off looking at where we stand in the plan next year and do the calculations as to reimbursement off of that, on that 39,298.82
Well,
after open enrollment next year?
well, or based on the number of participants from
Based on
this
the number
year.
of participants
Okay.
after open enrollment.
But, all right, that's where I thought we were headed in the first thing, was to look at the net number, and we wouldn't reduce what anybody was paying, but it might actually pay,
Yeah.
more. But
We'll never pay more than the 39,298.
But-
That would be the maximum amount that we would be.
okay, that's where we were. And this effort of this was to change that and set these and lock them in.
Well, it's pretty obvious we can talk about it and do anything to it we want to at any time.
Well, that's true too,
I mean,
but you've got
that should be
people-
quite obvious by
It's
now.
like Ms. Flores is saying, if you've got people announced, now they're getting out of it, then what Commissioner Harvey, I think, just said was you wouldn't redistribute that leftover money. So
That money goes back to the taxpayer. we are phasing this out. We agreed to do it and let it go at the end of 2020 one time, but we wanted to phase it out. So we agreed to phase it out, and we're gonna drop it like 25%. The county's portion will be reduced by 25% every year until we don't pay anything.
Wow.
And that means if you stay on there, great. If you get off, that means that the money that we were going to pay now goes back to the taxpayer. It doesn't go to your other employees to subsidize their payment. They're just gonna get 25% less money from the county for the next 4 years, and then we're done.
We agreed on a total phase-out,
We did.
total of $131,474.67. That was,
Right.
that was the agreement.
That we would
Next year,
dictate up to that amount. Not spend that amount, but up to that amount. And everybody that falls out just helps the taxpayer on this side. We're not gonna redistribute money. 25% less every year until it's done. That's what we agreed to. And then we hear, people playing the game. Well, I'm gonna get out, but I wanna give my money to so-and-so, and, they don't, because they need it, and, well, that's not the intent of this whole process. The process is to phase it out.
I put the program together, and the intent was to consider the attrition rate over time and use that attrition rate to bolster the reimbursement, so.
Okay, you and I agree on that. Commissioner Harvey doesn't. I'm not sure about Commissioners Muller and Watts. I had thought, what I tried to clarify with us, and I read back that motion when we did this, that we were putting this amount of money in it to
Each
be
year.
distributed. I agree it shouldn't go over what they were paying, but I
They
thought
never-
we were dividing up that money.
They never
with
get
those
more
on the
money than
plan.
they're getting right now. It drops. It drops every year.
Yeah,
But if 15 come off the program next year, we figure that distribution off of the 39,298 after open enrollment.
I don't agree with that at all.
the other thing that we have to look at that could change a bunch of that is if you drop, there's footnotes on those things about what percentage of people you drop off the plan may affect the other rates. That's in the footnotes, so, we've never had that. And I don't think we have 470, 490 people in the program, and 10% is the number they talk about. So, we don't have that many people in the grandfather plan, so I don't think we would hit that.
Well, it's pretty obvious, we're gonna review this insurance deal every year anyway. It's a moving target, and we don't know where we're gonna be a year
Yeah.
from now. And as I said
That has
earlier,
no bearing on what this court's,
No.
I think we set the rates for 2019 as shown, and then we revisit it.
you can do that without,
I want to make it clear.
Changing the motion.
I put this on here for a specific reason. I want to make it clear that I do not want it to be convoluted in any shape, form, or fashion, that the county's contribution on, I don't care what insurance premiums that we pay in the future, the county's contribution to this grandfathered employees will be 25% less on an individual basis every year until we're done. It doesn't, nothing else matters. You use those numbers to present to the court that, look, we can get out for like 131,000, and we said, okay, but that was the maximum amount to be spent, not a dedicated amount to be spent. If somebody drops out, if 10 people drop out, that money goes back to the taxpayer, not to be redistributed among the other employees. That is what I've got on this agenda today, and that's what we're voting on. You can vote me down if you want to, but that is my intent. Everybody needs to be on one page that we're phasing it out, 25% less every year until it's done.
Well, and is the number exactly 25%? I mean,
I don't know.
a rounded.
I don't know what it is.
But I mean, we broke the numbers out and we talked about the allocation each year. And hopefully that maybe with the creation, and it may not happen this year, Corey, but with the creation, if it's feasible, of an HSA, we help in another manner. We are able to maybe create something that would give some benefit with a larger deductible that we can pay back or pay down to some form, and we're hoping that that's what we find in this new insurance, is that we can increase our savings by increasing our deduction, but still be able to buy it down and pay either with the HRA shoring it up or moving to the HSA plan, somehow shoring that up. But it's a dilemma, because we all know that by 2022, those rates are going to have increased another 10-15% easy.
But what does that have to do with this?
Nothing.
Okay.
No.
I'm trying to get to a point that we can stop convoluting this, stop confusing people, and just let them know that the county's contribution moving forward in 2019 will be approximately 25% less. For the next 4 years, it'll drop approximately 25%, and then we'll be done. That's as simple as you can make it. Now, you can convolute it if you want to, and make it where we got to work our butts off trying to figure out what we're going to pay and when we're going to do it. Or we can make it simple. Keep it simple.
My only comment to that is that as this fades out under these dedicated amounts here, or these maximum amounts here, that we are diligently, I would really relish the fact that more than 27 people can participate in family, spousal, child coverage. And that's what we've got today, is only that amount of people participating because they're subsidized.
Right.
And we
No one else
want
can.
something that doesn't have to be that way.
Absolutely.
But that is great, but it doesn't have anything to do
No.
with this.
Okay, that difference from this year of 67,831.26, then going down to 39,298.82 is more than 25%, Commissioner Harvey.
It should be at 50% by then. The 39,298.82 should be the maximum amount at 50% subsidy. 25, 50, 75, and 100.
25 from this year. But between those years,
There was already a known attrition that was taken out.
that's what you've got.
Yeah, that's what's happening,
Already
is
a
that
known.
the total
Okay.
amount,
The
the
four
attrition's
people.
kicked in.
Yeah,
Yeah,
there was a known, and that whole plan was based upon.
So that's the maximum amount.
yeah. Okay. Any other comments? Okay. We have a second to Commissioner's motion.
Yes, I'll second the motion.
Okay. All in favor, signify by saying aye.
Aye.
Opposed, same sign.
Aye.
Aye. Motion carries 3-2. Okay, we're down to public comments. Anyone in the audience? Okay. Commissioner Beecham,
I had nothing, Judge.
Commissioner Harvey.
I want to remind everybody that we have a feed coming up on October the 4th, and I've been reading a little bit about this. It's going to it could make a big impact in our community with our kids. And I hope that the word can get out and people can attend this banquet and learn about what they're trying to do is to change the behavior or recognize the behavior of our children and act on it at an early age to direct them down the right road. So it's the biggest step I've seen in a long time towards reducing our jail numbers, you know.
It puts everybody on the same page, families, the law enforcement, education, everybody on the same page together, working for a common goal to affect children of abuse, neglect, any adverse childhood experience, so.
You can work with these kids and they're less apt to have alcoholism, diabetes, depression. I mean, I didn't realize that early childhood development is big time important. And if you got a kid that's exposed to a huge negative background, and if you get a hold of them quick, it can make a difference in their life. So I think it's really innovative, the stuff I've been reading on it, and I hope you guys pay attention.
This is actually done as a program from United Way with grants coming from both federal and state. It does identify it. Most of us in here would probably take this survey. There's 10 questions. Most of us in here would answer no to all those questions. But they're finding that if you answer 3 or more of these positive, that yes, that happened to you in your childhood, that increases everything from health risk, physical health risk, mental health risk, and to become criminal participant in society.
Yeah, for every factor you answer yes to, your likelihood to be affected by obesity, drug abuse, alcoholism, it goes up commensurate with every number that you answer yes to. So if you answer yes to all 10, your line's almost straight up. You're every factor that you can imagine, you're at a high risk for. So it's,
Commissioner Waller.
No, just, and I promise you, you'll eat well. That'll be
feed you good.
worth the trip, anyway. Judge, we did make a good decision on our burn ban deal. I've had several people mention it, giving us a chance to get some stuff cleaned up before frost, which we'll have danger again, especially with this kind of rain. So that was a good thing. I just want to bring everybody's attention to that if you've got some of that to do, timeliness will be important.
What can you do about the house flies?
Yeah.
Oh, my word.
And as always, if you're gonna do a burn, call your local fire department, let them know.
Yes.
They'll appreciate the courtesy, and it makes the system work a whole lot better. Just let them know, and they'll work with you.
Commissioner Watts.
We've had a tremendous wash out on the end of County Line Road that is going to approach County Line. We're going to have to get that trend turned. Called Eileen this morning and got her to coordinate with that Joe
The
and
engineer.
take a look at maybe what we could do. The washing of that sand is just very difficult to control, and it's running right at our road. We had a culvert fail on Flushy Road, and we've got barricades up on it. Water just too much and washed out some of that. We've had reports of well over 6 inches north of Electra, so we know that it was just a large impact to us. It hit us suddenly, and we're dealing with that. But that's what we've got going on right now, and hopefully we'll get those arms around those both things real quickly.
Okay. Tomorrow night at the Museum of North Texas History, they're having boots on the ground, and when I first heard that, I was thinking of
Military.
black military boots. That was my boots on the ground, but it's cowboy boots, and it's a really interesting collection of those, and so if you feel like going and sporting that, I think you'll find it a good time. I will be in Austin Thursday and Friday for a Judicial Education Committee meeting, and we're planning the 3rd annual probate conference, and that'll help the new judges coming in to gain some probate information on what they'll be seeing in their courts.
Judge, at the museum, don't they have Nat Fleming's hat collection
Yes.
down
Yeah.
there? If you guys have never seen that, that's pretty cool.
It is, it really is. We have a new museum director over there also, and a young lady, this is her first director assignment. She's really nice, and if y'all get a chance to go over and meet her, that'd be great. All right, it is 11:11, and we're adjourned.
11:11.
And the air conditioning works.